Welcome to the deep dive. Imagine you're watching one of those legal dramas, or maybe you've had a minor brush with the law yourself. There's this huge, complicated legal system working behind the scenes, dictating everything from an arrest right through to a trial. Today, we're going to try and unpack a really foundational piece of that puzzle, the Criminal Procedure Act of 1977.
And it's so important to get that this isn't just some old document gathering dust on a shelf, not at all. This act is, well, it's alive. It's constantly being updated, amended, changed. Our sources show amendments stretching way back, but also right up to recent times, like the 2023 Hate Crimes Act being woven in. It's always adapting.
Exactly. So our mission today is basically to give you a shortcut to understanding something that, well, it touches everyone's lives, really, whether you realize it or not. We want to get past the headlines, look at the actual mechanics, the nuts and bolts. We're aiming for clarity, maybe some of those aha moments of detail for you to get the gist, but also maybe spark an interest if you're leaning towards law.
Okay, so let's kick things off. At its absolute core, what does this act actually do? What's its main job?
Well, put simply, its purpose is to make provision for procedures and related matters in criminal proceedings. Basically, it sets the rules of the game for how criminal cases are handled, start to finish. Think of it as the official playbook. And like we said, it's a consolidated act.
Consolidated.
Meaning it's the original 1977 law plus all the changes made since then, all rolled into one single up-to-date document. That's why you see amendments from 79 all the way to 2023. It keeps evolving. Got it. A living playbook. Now, here's something that I think surprises a lot of people. This idea of private prosecution. How does that even work? Who decides if a case goes forward?
Right, that's covered early on in Chapter 1, dealing with the prosecuting authority. Mostly, it's the state, the Director of Public Prosecutions, or DPP, or a prosecutor acting for them. They have the power to prosecute, obviously, but also to withdraw a charge before someone pleads. Or, importantly, they can stop a prosecution after a plea, but before a conviction.
And stopping it after a plea is significant, isn't it?
Hugely significant. If they stop it after a plea, it results in an acquittal. The person is found not guilty. They can't be charged again for that same offense based on the same facts. Now, for a prosecutor who isn't the DPP to stop a prosecution, they usually need authorization, and they need to consider things like the offense, the accused, the community interest.
Okay, but the private prosecution part, that feels different.
It is different. It's quite extraordinary, actually. Section 7 allows for it. If the DPP formally declines to prosecute, they issue something called a certificate noli prosequi, basically saying, we won't pursue this, then a private individual might be able to step in.
Might. So there are conditions.
Oh, absolutely. Big conditions. The key one, Section 7(1)(a), says the private person has to prove they have a substantial and peculiar interest in the trial because of some injury they personally suffered. It's not just about feeling strongly about something, it's about direct harm.
So like a victim of the crime.
Exactly. Or close relations. A husband if the wife was the victim, a wife or child if the offense caused a death, a legal guardian for a minor. And there are safeguards. Section 9 requires the private prosecutor to put down money as security for costs. Part of that is set by the minister, another part by the court to cover potential defense costs for the accused.
So you can't just launch a private case lightly.
Precisely. If you don't pursue the case diligently, you forfeit that security deposit to the state. It's an avenue for justice if the state declines, yes, but it's got serious checks and balances. A real last resort in many ways.
Okay, moving from who prosecutes to how investigations happen. Let's talk about those moments when authorities might knock on your door or stop you. Search and seizure. What are the rules there?
That brings us to Chapter 2. It covers search warrants, entering premises, seizing property, and what happens to it afterwards. The general rule: police need a search warrant to seize items linked to an offense. A magistrate or justice issues it based on reasonable grounds, or a judge if it's specifically about getting evidence for a trial.
I heard there was a recent change making it easier to get warrants across different areas.
That's right, a significant tweak in 2023. Section 21(1)(a) now says an application for a warrant can be made to any magistrate or justice. It doesn't matter where the crime happened or where they plan to search. It definitely streamlines things jurisdictionally.
And executing the warrant.
Yeah.
Any rules around that?
Yes, warrants are generally executed by day unless the warrant specifically says otherwise. And Section 25 deals with entering premises. Warrants can be issued for things like national security or preventing a crime. Police can act without a warrant to enter premises, but only if getting one would cause a delay that would, defeat the objects, like if evidence was about to be destroyed.
So the rules seem clear. But what if an officer doesn't follow the rules? Is there any real comeback? This feels like a crucial aha moment for listeners.
There absolutely is, and it's under Section 28, titled Wrongful Search and Offense. It's quite explicit. A police official acting against the terms of a warrant or searching without proper grounds or authorization is actually guilty of a criminal offense.
Seriously, what's the penalty?
It could be a fine up to R600 according to the Act as written, or even imprisonment for up to 6 months. And there's more. Section 28(2) says if someone gets a warrant based on false information and that informant is later convicted of perjury for lying, the court can order them to pay damages to the person who was wrongly searched.
Wow, that's a real safeguard against abuse of power.
It is. It provides genuine recourse. And related to that, Section 29 insists that searches must be done decently and orderly. And critically, it specifies that if a female person is searched, she shall be searched by a woman only. That's about dignity and respect.
Okay, so the Act covers traditional police work. But the world's changed. What about things like DNA, fingerprints, even virtual courtrooms? How does a 1977 Act handle that?
It's had to adapt significantly. Sections 36A through 37 deal directly with forensic evidence like DNA and fingerprints. Section 36A defines key terms like forensic DNA profile. Importantly, it clarifies this profile is just a unique identifier in alphanumeric string and specifically excludes information about health or medical conditions apart from indicating sex.
That's an important privacy distinction. Who has to give these samples?
Well, the Act specifies categories. People arrested for serious offenses listed in Schedule 8, people released on bail sometimes, if prints weren't taken, those convicted of certain crimes, people on the National Register for sex offenders. But again, there are protections. For intimate samples, think blood samples, things like that. Section 36D is very clear.
How so?
They can only be taken by a registered medical practitioner or a registered nurse. And it must be done with strict regard to decency and order. That's a non-negotiable standard. And there's a crucial data protection element, too. Section 36B3 says if someone isn't prosecuted after all, or they're found not guilty, or a conviction is overturned on appeal.
Yes. What happens to their prints or samples?
Their fingerprints and body prints must be destroyed within 30 days. That's a key safeguard for privacy after the legal process concludes in their favor.
That's really good to know. And the move towards digital justice, video links in court.
Yes, that's covered in Sections 159A to 159C, brought in by amendments in 2008 and updated again in 2021. It allows courts to use audiovisual links, video conferencing for certain proceedings, especially postponements.
Why do that? Just for convenience?
It's partly about efficiency, preventing unreasonable delays, saving costs, convenience, yes, but also for substantive reasons, like state security, public safety, or crucially, to prevent prejudice or harm to a person testifying, maybe a vulnerable witness.
Are there checks to make sure the accused person's rights aren't lost in the technology?
Definitely. The law insists the accused must be appearing from a place where they can consult privately with their lawyer. That's fundamental. And the court must, at every appearance via video link, ask about the accused's physical and mental well-being. So technology serves justice, not the other way around.
Okay, let's shift gears to what many people probably picture first when they think criminal procedure. The arrest itself, and then the whole process of trying to get bail.
Right. That takes us to Chapter 5 on arrest and Chapter 9 on bail. Big topics. Section 39 outlines the manner of arrest. It can be with or without a warrant. It involves actually touching the person or, if necessary, forcibly confining them. And crucially, the person being arrested must be told the reason for the arrest, right then or as soon as practically possible.
You mentioned arrest without a warrant. When can police do that? Seems like a lot of power.
It is, but Sections 40 and 41 lay out specific circumstances. Peace officers can arrest without a warrant if they witness someone committing a serious offense, like those listed in Schedule 1, or if they find someone possessing a dangerous weapon unlawfully or someone escaping custody, or in cases of domestic violence. They can also arrest someone who refuses to give their name and address, or gives a false one. They can detain them for up to 12 hours just to verify their identity.
And I think I read something about a citizen's arrest. Is that actually a thing?
It is. Under Section 42. A private person, like an owner or occupier of property, can arrest someone they find committing an offense on their property. Though they then have to hand the person over to the police, of course.
Okay, and then comes the famous 48-hour rule. That's a bedrock principle, isn't it?
Absolutely fundamental. Section 50 is crystal clear. If an arrested person isn't released sooner, maybe on police bail or a warning, they shall be brought before a lower court as soon as reasonably possible. but not later than 48 hours after the arrest.
48 hours, that's it.
That's the maximum unless the 48 hours expires outside normal court hours, like on a weekend or public holiday. In that case, they must be brought to court by the end of the next court day. It's a vital protection against being locked up indefinitely without judicial oversight. It forces the state to justify the detention before a magistrate or judge quickly.
So you're brought to court, then comes bail. How does that decision get made? It seems complex.
It is complex, and it's governed by Section 60. The core principle is the interests of justice test. The court has to weigh the personal interests of the accused, like their liberty, their job, their family, against the broader interests of justice.
And what falls under interests of justice?
Section 64 lists specific grounds for refusing bail. The court looks at the likelihood of the accused endangering public safety, or maybe fleeing absconding, or interfering with witnesses, trying to destroy evidence, undermining the justice system, or even committing another serious Schedule I offense while out on bail. It also explicitly includes considering the safety of any person against whom the offense in question has allegedly been committed.
So it's a real balancing act. What specific things does the court look at?
All sorts of factors. Section 60 subsections detail things like: does the accused know the witnesses? Is the investigation finished? How easy would it be for them to hide evidence? How common is this type of crime? Even the accused's state of health can be considered. And importantly, the accused or their lawyer has a duty, Section 60, 11b, updated over the years to tell the court about any previous convictions, other pending charges, if they're already out on bail for something else, or if there are protection orders against them.
They have to disclose that.
Yes. Failing to disclose or giving false information is actually an offense itself. It's about ensuring the court has the full picture to make that crucial interests of justice decision. And if bail is granted, the court can impose conditions reporting to a police station, surrendering passports, things like that, again, in the interests of justice.
And if you disagree with the bail decision?
There are appeal processes under Section 65 and 65A. The accused can appeal a refusal or the conditions imposed. And the state, through the DPP, can appeal if they think bail shouldn't have been granted or if the conditions are too lenient.
Okay, so now we're in court. The case is proceeding. What about the actual charge, the plea, the evidence? How does the Act regulate the rules of the game inside the courtroom?
Right. Chapters 14, 15, and 24 cover this, starting with the charge in Chapter 14. Section 84 says the charge must have enough detail, time, place, who was involved, what property, etc., to properly inform the accused of the nature of the charge. Fairness is key. If it's defective, it can usually be amended. And interestingly, this is where we see the Constitution's impact again. Section 245 used to create a presumption related to false representation, but the Constitutional Court struck it down in 97 as unfair. The Act evolves.
That constant evolution is striking. Now, please, we hear about plea bargains in other systems. Does South Africa have something similar?
Yes, we do. Thanks to Section 105A, which came in back in 2001. It allows for formal plea and sentence agreements. This is a big aha moment for many. It means the prosecutor and the accused, usually through their lawyer, can negotiate an agreement on the plea likely guilty and the sentence before the trial really gets going.
So they negotiate the outcome. Does the judge get involved in that?
No. Crucially, the court does not participate in the negotiations themselves. That maintains judicial independence. Once an agreement is reached, it's put to the court. The judge must confirm the accused understands it, is agreeing voluntarily, and be satisfied that the accused is actually guilty based on the agreed facts. Then the judge can either impose the agreed sentence or, if they think a different sentence is appropriate, they tell the parties. If that happens, both the state and the accused can choose to withdraw from the agreement entirely.
So it offers efficiency, but with judicial oversight.
Exactly. It speeds things up, provides certainty, but the judge still has the final say on whether the agreed sentence is just, protecting against unfair deals.
And evidence. That must be a huge part of the Act. Any key highlights on how evidence is handled?
It is huge, Chapter 24. But some key points stand out for practicality and fairness. Section 212, for instance, allows many facts to be proven simply by submitting an affidavit or a certificate. Think expert reports, biology, chemistry, physics, fingerprints. even computer science analysis or business records. This avoids dragging experts to court for routine matters, making trials more efficient.
What about confessions? Always a contentious area.
Very much so. Sections 217 and 219A deal with confessions and admissions. The core rule is voluntariness, they must be freely made. And there's a critical safeguard in Section 217(1)A. A confession made to a peace officer who isn't a magistrate or justice is only admissible if it's later confirmed and reduced to writing in the presence of a magistrate or justice. That's a major check against coercion.
And witnesses. Can spouses be forced to testify against each other?
Generally, no. Sections 195 and 196 cover this. A spouse is usually competent to testify for the prosecution, meaning they can, but they are not compellable, meaning they can't be forced to. There are exceptions, mainly for offenses committed by one spouse against the other or against their children. For the defense, a spouse is competent, but an accused can't be forced to testify against themselves, and a spouse can't be forced to testify for a co-accused.
Again, we see that balancing act and vulnerable witnesses, children, for instance.
Yes, Section 170A is very important here. It allows for evidence through intermediaries. This is for witnesses under 18 or those with mental disabilities or anyone likely to suffer undue mental stress or suffering from testifying directly. An intermediary, a trained professional, conveys the questions from the lawyers and the judge to the witness and conveys the witness's answers back. It shields the witness while still allowing their evidence to be heard.
Okay, fast forward. A verdict is delivered.
Yeah.
What happens next regarding sentencing? And a question many people have. If someone has served their time, can they ever truly move on? Can a record be cleared?
Right. Chapter 28 deals with sentence, and Chapter 27 with previous convictions, which links to expungement. Section 276 lists the main sentencing options courts have: imprisonment, fines, periodical imprisonment, like weekend jail, correctional supervision, house arrest, community service, declaring someone a habitual criminal, and others. There's also provision for suspended sentences under Section 297. A court can postpone passing sentence or pass sentence but suspend all or part of it, often on conditions like paying compensation or doing community service, or even just discharge someone with a caution.
And victims, do they have any say after conviction?
Increasingly, yes. Section 299A, updated significantly, gives complainants or their relatives in serious cases, murder, rape, serious robbery, the right to make representations when the offender is being considered for parole or placement under correctional supervision. They have to actively inform correctional services they want to do this, but it gives victims a voice later in the process. It shows a move towards more victim-centric justice.
Now the big one, expungement. Can a criminal record actually be wiped clean?
Yes, it can, and this is a really powerful aspect introduced by amendments, mainly around 2008 and 2013. It's about second chances and restorative justice. There are two main rights. Firstly, under Section 271C, there's automatic expungement for convictions under specific old discriminatory apartheid-era laws. Think the PASS laws, the Mixed Marriages Act, the Group Areas Act, even the Terrorism Act of 1967. Those records are automatically cleared.
That's addressing historical injustice directly. What about more common offenses?
That's where Section 271B comes in application-based expungement. If someone received a relatively minor sentence, like a postponed sentence that was later discharged, or just a caution, or certain types of fines or short prison terms for less serious crimes, they can apply to have their record expunged after 10 years have passed since the conviction.
10 years, provided.
Provided they haven't been convicted of another serious offense during that 10-year period. They need to make a written application to the Director General of Justice. It's a crucial mechanism. It allows people who've stayed on the right side of the law for a decade to truly move forward without the stigma of certain past mistakes holding them back indefinitely.
That's incredibly significant. Finally, the justice system isn't always swift. What happens if a trial just drags on? And what if you genuinely believe the outcome was wrong?
Two vital safety nets. Section 342A tackles unreasonable delays in trials. This was brought in specifically because delays can severely prejudice everyone involved. The court must investigate if a delay seems unreasonable and is causing substantial prejudice.
And if it finds the delay is unreasonable, what can the court do?
It has real teeth. It can refuse any more postponements. It can grant one last postponement, but with strict conditions. It can strike the case off the roll if the accused hasn't pleaded yet. Or, significantly, if the accused has pleaded, the court can order a stay of prosecution, which effectively ends the case permanently due to the delay. The system is designed to push for timely justice.
And the final recourse, if you think the verdict or sentence was wrong.
That's the appeal process, covered mainly in Chapter 30. An accused person generally has the right to appeal their conviction or sentence from a lower court to a high court, or from a high court judgment to the Supreme Court of Appeal. Usually, you need leave to appeal permission from a court, but it's a fundamental check. You can also apply for a special entry on the record if you believe a serious irregularity or illegality occurred during the trial itself. The appeal court has broad powers to confirm, change, or completely set aside the lower court's decision. It's the ultimate safeguard against miscarriages of justice.
So wrapping this all up, we've really covered a lot of ground, haven't we? From arrest to appeal, through this incredibly detailed Criminal Procedure Act of 1977.
We certainly have, and I think the key takeaway is that this act, with all its hundreds of sections and decades of changes, really is the procedural heart of the criminal justice system. It dictates how things are done, step by step, from search warrants and bail hearings to using DNA and video links, how evidence is presented, how sentences are decided, and even how old records might be cleared. And it's always evolving.
It really underscores that justice isn't just about the final verdict, is it?
Not at all. It's profoundly about the process, the fairness of every step, the protection of everyone's rights, the accused, the victim, the public, and that constant, difficult balancing act between individual liberty and keeping society safe. So maybe the next time you hear about a court case, even something seemingly small, you can think about this complex, invisible framework beneath it all, this act shaping every single interaction, every decision.
A framework designed ultimately to ensure that justice is not just done, but seen to be done fairly. Something crucial to remember.